Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. Guys, this is my Facebook page, and if you want to join us, if you're fighting foreclosure, you can join my private group. And we talk about all kinds of things foreclosure related, and we share our emotions with each other and we help each other out. So you're welcome to join my group. Just send me a email or a text message, and we'll get you in with this group. Okay guys, today we're going to talk about my friend Sabrina Kohler. She's in Missouri, and her case, if you want to go into PACER, is 424CV01020. Kohler versus Broker Solutions Inc. And it was filed on July 25th, 2024. Date of last filing was August 30th, 2024. So you can see the history of her complaint. You can also look at the documents that were filed, or you can come to my Facebook page. We have most of these already on record there. If you needed to look at any of these, just let me know. The last thing that the other side filed was a motion to dismiss and a memorandum in motion to support a motion to dismiss. And so let's take a look at what that looks like. Okay, so let's see here. The motion to dismiss, this is the one they filed on August 30th. Basically, they're trying to argue that she doesn't have subject matter jurisdiction in the federal court because most of her complaints involve violations of state statutes. And without getting into their stupid arguments, they're just trying to mainly say that her complaint fails to establish a basis for subject matter jurisdiction in federal court. And so, you know, it's not a very good motion in my opinion, but it's better than trying to defeat a Rule 12b-6 motion to dismiss. So there's that. Okay, so let's take a look at what Sabrina's going to file in response. First, she's going to file her opposition to motion to dismiss, which looks like this. And she says here, come now Sabrina Kohler, pro se, and files this opposition to Defendant Broker Solutions, doing business as New American Funding, NAF, motion to dismiss plaintiff's first amended complaint, FAC. Defendant contends that the court lacks subject matter jurisdiction over the claims presenting in the FAC. Plaintiff's concurrently filed memorandum of law demonstrates that federal jurisdiction is proper under both federal question and diversity jurisdiction. Respectfully submitted. Okay, now that's the first part. And then the memorandum of law part, let's look at that. This is her memorandum of law in support of opposition to motion to dismiss, as you can see here. Cover page, table of contents. The basic structure is introduction, standard of review, legal framework for subject matter jurisdiction, argument, diversity jurisdiction, complete diversity, amount and controversy, supplemental jurisdiction, relation of claims, state law claims, supporting authority, conclusion, and prayer for relief. And the case law, table of authorities, is here, and we'll go over this. And as you can see in parentheses, we touched on what case supports her argument. And then there's the 28 U.S.C. 1331, 1332, and 1367. Okay, and so the introduction basically states that Sabrina Kohler respectfully submits this opposition to Defendant Broker Solution, doing business as New American Funding's motion to dismiss for lack of subject matter jurisdiction. Contrary to defendant's assertions, plaintiff's complaint establishes a basis for federal jurisdiction, either through a federal question or diversity of citizenship. Standard of review. In evaluating the motion to dismiss for lack of subject matter jurisdiction, the court must accept as true all well-pleaded allegations in the First Amendment complaint, FAC. The burden of proof lies with the party asserting jurisdiction to demonstrate its existence by a preponderance of the evidence. Legal framework for subject matter jurisdiction. Federal courts have limited jurisdiction and may hear cases based on either federal question jurisdiction under 28 U.S.C. 1331 or diversity jurisdiction under 28 U.S.C. 1332. Plaintiff's complaint addresses both bases for jurisdiction. Argument: diversity jurisdiction. And we have a footnote here that kind of goes over what that really means. Under 28 U.S.C. 1332, diversity jurisdiction exists when there is a complete diversity of citizenship between parties. Plaintiff resides in Missouri, and the defendant is based in California. See First Amendment Complaint, page 5, paragraph 2. See Caterpillar, Inc. versus Lewis. That's one of these case law sites here that we're talking about that ruled that diversity jurisdiction is permissible if diversity is complete at the time of judgment by the federal court, even if it was not complete when the court first assumed jurisdiction. Amount in controversy. The complaint asserts that the amount in controversy exceeds $75,000, exclusive of interest and costs. See First Amendment Complaint, page 5, paragraph 2. The Supreme Court in ExxonMobil Corp. Versus Alipata Services supports the notion that the amount in controversy must be reasonably inferred from the allegations. Plaintiffs' claims for damages, including compensatory, punitive, and statutory damages, collectively exceed this threshold. The case of Strawbridge versus Curtis confirms that diversity jurisdiction requires no plaintiff and defendant to be from the same state, which is satisfied here. Supplemental jurisdiction. Relation of claims. To promote judicial efficiency and avoid piecemeal litigation, plaintiff seeks supplemental jurisdiction over related state law claims, as these claims share a common nucleus operative facts with federal claims. See United Mine Workers versus Gibbs. The state law claims, fraud, breach of contract, conversion, breach of good faith and fair dealing, unjust enrichment, forgery, slander of title, are sufficiently related to the diversity claims warranting supplemental jurisdiction. Pursuant to Erie versus Tompkins, this court must apply Missouri's substantive law to plaintiff's claims, ensuring consistency and avoid forum shopping. In Hanna versus Plummer, allows federal courts to apply their procedural rules while adhering to state substantive law. Supporting authority. The court in Gasperi versus Center for Humanities supported the exercise of supplemental jurisdiction over state law claims closely related to federal claims, which is applicable here. Conclusion. In conclusion, this court has supplemental jurisdiction over plaintiffs' related state law claims: fraud, breach of contract, conversion, breach of good faith and fair dealing, unjust enrichment, forgery, slander of title, due to their shared common nucleus of operative facts with the federal diversity claim. Plaintiff's First Amendment complaint establishes federal jurisdiction under both federal question and diversity jurisdiction. Accordingly, defendant's motion to dismiss for lack of subject matter jurisdiction should be denied. And prayer for relief. Plaintiff respectfully requests this court deny defendant's motion to dismiss and grant such other relief as the court deems just and proper. And then there's always a certificate of service to serve the other side's attorneys. Okay, guys. So that's what we talked about today, so everybody can see how Sabrina's doing with her case. And if anybody has questions about this case, you can send me an email. My email address is foreclosurehelp777@gmail.com. If you subscribe, thank you for subscribing and liking this channel. And I hope everyone has a blessed day.